Uh, but we know that that's not what in fact happened. Dr. Bloomberg and Dr. Derringer both agree that there was a phone call placed by Dr. Derringer and that there was information provided by Dr. Bloomberg that he was on his way in. The ultimate issue being this individual needs a surgical intervention. Dr. Derringer is not a surgeon. He did in fact take the step which we would like to see, which is calling the surgeon to say, "Where are you?" The surgeon saying, "I'll be right there." I think that addresses a lot of the other points in the bill of particulars that you've raised by your question, which are, why didn't you call another surgeon? Why didn't you go directly to the operating room? Why didn't you do X, Y, and Z? I was told by the ED that there was this plan in place. When I called to confirm the plan, I received information confirming that the plan was in place. And that's how Dr. Derringer is separate from the sort of tangled web that exists over here with Dr. Rainville and Bloomberg of, well, yes, you called me, but maybe you didn't tell me how severe it was, those kind of things. The information that was supplied to Dr. Derringer was, there's a plan, it's urgent, everyone knows it's urgent, they're acting on it. And he got the same information essentially when he called Dr. Bloomberg to confirm, "Where are you?" "I'm right up, I'm on my way, I'm coming in."
The plaintiff created an issue of fact, perhaps, then that not maybe with respect to the call being the calls being made quickly enough that the information transmitted was complete enough, that the full extent of the plaintiff's decedent's condition, essentially with the active bleeding, that wasn't communicated effectively by Dr. Derringer. So that those on the other end of the line didn't appreciate the sense of urgency.
I understand your question. And not to beat a dead horse, but I think it falls into the same thing. The information that Dr. Derringer had available to him from his second conversation with Dr. Rainville was that the urgency of the situation had been expressed to Dr. Bloomberg, and that was why he was coming in. When there's the second phone call, or Dr. Derringer's first phone call to Dr. Bloomberg, but really the second phone call to Dr. Bloomberg that day, Dr. Rainville's being the first, Dr. Derringer receives information, yes, in fact, I am on my way in. I'm not saying that absolves Dr. Derringer of any duty to continue to provide preoperative stabilization to the patient, but that certainly resolves the issue of, is there a surgeon on their way? Yes, there is a surgeon on their way, and he's on his way in. And that is consistent with the information that he originally received from Dr. Rainville, which is, I've contacted a surgeon, they're on their way in, they know that it's urgent. When he made the phone call, he couldn't say the full contents of the call in his deposition, but it was essentially, yes, I'm coming in. So when you look at those two pieces of the puzzle, as Dr. Derringer is hearing it, as he's live providing care, there's a plan in place, it's urgent, and when I call to confirm that plan is in place, the plan is in place and there's a surgeon coming in to perform the surgery that needs to be done. And that informs this issue of whether the order needs to be, there's a question in the papers about whether Dr. Derringer's second order for a consult needs to be stat versus routine. And Dr. Derringer in his deposition testimony essentially says, stat, routine, it doesn't matter. There's a plan in place. And if there's not a plan in place, then I reach out and make sure that that there is one. And in both instances here, he did understand that a plan was in place. And then when he sought to confirm it, received information confirming that that plan was in fact in place. If I could just turn to, unless there's any other questions on that point. If I could just turn briefly to, I think, another aspect of your question there, Justice Nowak, which is issues that the plaintiff's expert did not address in their answering papers under the Carroll decision. I think there were 5 that I identified. The failure to take a history, it's documented. Failure to perform a medical exam, the fact of the exam is documented in the record. Failure to consider the patient critical. Paragraph 24 of plaintiff's expert's own affidavit acknowledges that Dr. Derringer considered the patient to be critical. Failed to arrange for admission. The patient was already admitted to the hospital by the time Dr. Derringer saw them. That's how you get to the ICU. You have to be admitted. And failure to transfer. The idea of transferring this patient to another hospital probably would have been terrible in any event, but certainly the plaintiff's expert was silent on that issue. And if there's no other questions, I'll rest.
Thank you.
Good afternoon. May it please the court, Catherine Dempsey for the plaintiffs. With all due respect to Mr. Britt, I think he is ignoring about the hour and a half before he started talking about the 3:30, 4:30 time that Dr. Derringer is carrying for plaintiff's decedent. And I want to start there because what happened in this case is Mr. Gumkowski's in the ER. He's being taken care of by Dr. Rainville. Dr. Rainville, approximately at 2:30 p.m., calls over to the ICU and talks to Dr. Derringer. And Dr. Derringer is informed at that time about his vitals at 12:37 and 1:30 about the blood work that's been done, about how his status is. And Dr. Derringer does not deny that he was informed of that during that 2:30 call. And importantly, during that 2:30 call, he accepted Mr. Gumkowski as his patient. But what happens after that is he doesn't realize or take due cognizance of how critically ill Mr. Gumkowski is, because the expert says, hey, if you realize how critically ill Mr. Gumkowski was, you'd intubate him, you'd place a central line, and you'd arrange for a stat surgical consult. But he didn't do any of that at 2:30. Instead, what happened was Mr. Gumkowski stayed in that emergency room for another hour, even though he was a patient of the ICU. And in that hour, nobody cared. No physician came, no physician cared for Mr. Gumkowski. He's a patient of the ICU, a patient of Dr. Derringer, and he just stayed there with no intervention, this critically ill patient. And so then he gets transferred at 3:30. And supposedly at that point, he is examined by Dr. Derringer. But Dr. Derringer does the examination and doesn't do anything for him at 3:30, doesn't intubate him, doesn't place a central line, doesn't realize, hey, no surgeon has seen this critically ill patient. I've got to get a surgeon in here. No, instead,
Wasn't he already advised of the plan that a surgeon was being made, that was being made by Rainville? I think that was communicated to Dr. Derringer at that point in time. So he's aware that there's a plan in effect, there's a doctor coming or a surgeon coming.
That a surgeon is supposed to be coming. But our expert is very clear that says, hey, you got a critically ill patient, the surgeon's not coming, then you don't just sit there and, twiddle your thumbs. You call another surgeon, you call that surgeon, you say, come in here and see this critically ill patient.
You put that in your bill of particulars, all right, but it's not in the complaint. Isn't that an issue here?
I don't think so, Your Honor. The bill of particulars absolutely expounds on the complaint and gives the specifics of what we are preparing for trial and everything. I have not seen a case where we say the delay is needed. The surgeon's delay has to be in the complaint. It's all in the bill of particulars.
Well, you're in the bill of particulars, you're talking about transferring to a higher level of care.
Well, okay, so transfer, I will agree with Mr. Britt that the transferring of the higher level of care to a different hospital and arrange for admission is something that we did not focus on in our summary judgment motion. And that's because when you do the bill of particulars, you put it all in, discovery goes. I didn't take those out of my bill of particulars, and I didn't make that a point in my summary judgment motion, my affidavit in opposition. Instead, the expert says, even though there's a plan in place, if a surgeon has not seen this critically ill patient from 2:30 to 3:30, which is the hour he's languishing in the ER, from 3:30 to 4:30, still no surgeon has seen it. And it's not until Mr. Gumkowski is worsening. Thank you, Mr. Britt, decompensating. It's been a long morning here. And only then does he call the surgeon. And our expert is very specific that this delay is not appropriate. It is below the standard of care. This was a patient of Dr. Derringer's, and he's not being painted with the same brush as Bloomberg and Rainville. He's very specific in his exact deviations that he attributes to Dr. Derringer in this case. And he says with proximate cause that based on what his status was, his blood work, his cognition, that if Dr. Derringer had acted appropriately, had intubated him, had placed a central line, had followed up with a surgeon, that Mr. Glemkowski more likely than not would have avoided his injuries and death. Just really briefly, it wasn't brought up during Mr. Britt's argument, but I'd like to draw attention into the failure to address certain parts of our claims. It is plaintiff's position that defendant did not make a prima facie case, and the burden did not shift. And there I lay out the exact theories of negligence that Mr. Britt did not address in his argument or in his papers. And let me see. And this, and I think that's everything, unless there's something that the panel would like to discuss. I'm happy to answer any questions on that one. And the other two that I'm going to stand up here for too.
Very good.
Thank you.
Mr. Potenza?
Good afternoon. I know it's been a long morning. Chris Potenza from Hurwitz Fine on behalf of Thomas Schwab, MD, Megan Kurtz, PA, and Christine Pieri, RN. I'll try to make this as brief as possible. We basically have three arguments here. One is that we established that there was no, pre or intraoperative deviation from the standard of care. And that was essentially unopposed on the merits of this case. And the order should have limited the claims to, if we don't survive, or if the claims survive the next level of arguments, that it should be limited to, his post-operative care.
Counsel, I see how you kind of made those distinctions, and it felt a little bit in reading the papers, and then you get to it, I think, on pages 14, 15 in your brief, that these are theory, how you decide to classify theories of liability. What are your facts?
Right.
Besides to classify or consider theories of liability or plaintiffs, the way that you characterize the claims within plaintiff's negligence cause of action. So you've said it, preoperative, intraoperative, two separate theories, two separate claims. That's fine. Who sets it? Do you set it? Does a plaintiff set it? I looked at the plaintiff's bill particulars to see if there was a question. Plaintiff, what are your theories or claims, and do you organize them in this fashion? I didn't see it. I don't know whether the plaintiff would have done so anyway. Maybe not, but I didn't see the court doing it. It looked like the Roswell defendants did it, and that's okay, I suppose. But is that appropriate? Is that you can sort of set what are the theories, what are the claims? Because when we're looking at the allegations of the bill particulars, we have to fit them within theories and claims, right? And I'm just wondering how narrowly, how broadly, who does it, et cetera.
I think it's a reasonable interpretation to make based on the allegations in the bill particulars, so especially when you're talking about the individual defendants that were sued in this case. Remember, Roswell is not a party to this case. These are three individuals sued independently. Right. And they all have different roles in regard to the care and treatment.
Good point. And perhaps it's unfair to even classify them together as a group, that maybe they each are individual theories. But the point is at some point, should a defendant get together with the defendant's counsel, with plaintiff's counsel, and say, hey, what are the theories? Let's do this classification. Should we have a classification conference where we sit down and we group things into theories? Should the court be involved? What are your thoughts on that now as we embark on this new frontier? Perhaps.
I mean, those are good suggestions, I guess. It hasn't been the practice, but I think there's a real reasonable interpretation based on the bill particulars and the allegations as they're presented, how the claims stack up against these three individuals. And you've got really three defined, theories. One was interoperative. Was it reasonable and necessary? Was there informed consent? Was the patient aware of the risks? Was the surgery done correctly, successfully? And then did they attend to him appropriately after the fact? And I think those are really clear divisions that would make sense to narrow the focus if this were to get to trial on certain issues. On
So
what
my
the issues
question,
are.
I'm sorry. So my question is more hypothetical, that in this case, we don't have that concern that it's difficult to categorize.
Right, correct,
All right.
correct. So moving on to the next, if we separate, the pre and the intraoperative care and we get to the postoperative care, basically we have three individuals, Dr. Schwab, Ms. Kurtz and Ms. Pieri. Ms. Kurtz and Ms. Pieri are the ones are the only ones who have contact with the family post-discharge. And, even the evidence up to when he was discharged, he was kept there for a longer duration post-surgery. All his vitals, all his blood work was fine. There was no indication of any problems. The responses that they gave, Ms. Kurtz and Ms. Pieri gave to the family were appropriate. There were instructions to seek emergent care, go to the emergency room, call an ambulance, because Roswell's not an emergent care facility. If it leveled to that, okay, which is done, it's documented, it's in the records. Dr. Schwab has no knowledge of any of this. Really, the only evidence in the record when he is notified of any complaints or situations with Mr. Domkowski is the morning of the day he unfortunately passes. And he receives a call, or he's notified of it, and I think it's within the hour is when 911 is called that he's taken to the ambulance. So I don't think there's a reasonable interpretation that anything that he could have done or any knowledge that he had could have changed the outcome for Mr. Domkowski. They are all co-employees. So he's not necessarily, the knowledge imputed to those two, Ms. Pieri and Ms. Kurtz, can't be imputed to him. It's not his practice. They're all co-employees at Roswell Park. Roswell's not a defendant in this case. So I think our expert in our papers established that everything that all three of them did post-discharge was reasonable and, did not deviate from standards of care. They advised them on what to do. They advised them to seek emergent care if it got to that level, and which they did. They did call an ambulance. An ambulance came, the Kenton ambulance came and attended to Mr. Domkowski. He refused transport to the hospital. So they followed the instructions. Like the instructions that were given to them by these three defendants were then followed by the family.
Intervening then? Is that an
Yes,
intervening
yes.
cause?
So that's our third position on the case here, is that there's the superseding intervening cause because they were checked out. The emergent care was called, ambulance, fire personnel came. Again, his vitals did not alarm anyone, and he chose to not take a ride to the hospital. And then his condition then continued to get worse. So if there's any other questions, I'm happy to take them.
Thank you.
Okay.
Hello again. I'd like to start off with the quality of the defendant's expert in this case. One, he does not lay a proper foundation. We don't know what medical records he looks at. We don't know what depositions he looks at. He also says he looks at other documents. We have no basis of understanding what his opinion is based on. There is an absolute lack of proper foundation, which is required for defendant to make a prima facie case of entitlement to summary judgment. So that's one. Two, I pull out in my brief, I'm not used to, I do block quotes of paragraphs of allegations that we have in our bill of particulars that defendant's expert does not address, doesn't even come close to addressing. So, and against each one of the defendants. And there is absolutely no way under Wilbricht that defendant has made a prima facie case of entitlement to summary judgment because he's not even attempted to say there are no questions of fact for a jury to determine in this case. And I lay that out in my papers. If
You disagree with the notion that under Carroll, a defendant doesn't have to do that, and Carroll somehow disavowed Wilbricht.
Yeah, absolutely, Your Honor. Carroll is for the plaintiff, and this court was very specific that plaintiff does not need to address every allegation or every issue in summary judgment to be able to go forward with their case. It is not the other way. We can't, the way that Carol's written, we can't just flip it around and say, oh, well, they don't need to address everything that plaintiff has attempted. It just doesn't make logical sense because the bill of particulars lays out every allegation of negligence. And when a defendant moves for summary judgment, they have to address every allegation of negligence to say there's no question of fact to allow this case to go forward.
If they're looking for partial summary judgment though.
That was not something that was asked for in this case.
But just going forward, we're looking at disavowing certain things, but you're saying that. Plaintiff's not looking for partial summary judgment. Here, they're saying basically that how they broke it up into post, intra and pre, they're saying that, okay, you didn't answer that.
That could be possible in some case, but in this case, it's a conglomerate of all of these different issues that he doesn't,
I agree, I'm just saying.
But it might be if everything was knocked out for a certain theory of liability, possibly partial summary judgment, but here the allegations that aren't addressed are from pre, intra, and post, and so that would not work in this case, Your Honor.
In your experience, where does that narrowing occur? When does that narrowing occur in a medical malpractice case?
The narrowing usually does occur in preparation for trial. That would be my experience.
After expert disclosure, you can sort of see where the claims are and what are we really proving here, and how many days do we need? How much time do we need to keep folks?
Exactly, Your Honor. And that's why Wilbricht and its progeny, that's why the summary judgment stage is so different than preparing for trial. Then just briefly touching on our expert addresses each different individual in this case. Sure, Roswell is part of the court of claims, but in this case, Nurse Pieri, PA Kurtz, and Schwab are addressed by our expert. And what's also going back really quickly, because this is a case and will come up in our town argument too, is that in this case, the history and what the proof of the matter is that on the record is that plaintiff and plaintiff's decedent called Roswell upwards of a dozen times. And Roswell called the plaintiff. And so there's this interchange of, hey, I'm not breathing. I called 911. I can't walk. There's different times. And I'll get into specifics with the town and how it applies there. But here in this Roswell case, there are so many phone calls on this record, and defendant's expert does not address Roswell's failure to address those. And Kurt specifically, she is informed that he was having shortness of breath post-surgically, that he called 911, and Kurtz does nothing about it. Kurtz doesn't tell Schwab supposedly till the next day, and our expert is saying, hey, no, that's below the standard of care. And the question of fact, Dr. Schwab himself creates a question of fact in his testimony because he can't even remember when he was told about the issues with Mr. Gumkowski. So there are issues of fact all over this record, and they need to be cited.
Battle of experts then?
A battle of experts, sir.
Yeah.
Any other questions? Okay, thank you.
Your Honors, may it please the court, Robert Goodwin on behalf of the collective Town of Tonawanda defendants. Your Honors, this is governmental action taken by the town personnel when they interact with the decedent on January 16th. This makes it a special duty case, and that's significant for two reasons. One, you need to put in your notice of claim and in your complaint some allegations that a special duty was violated, or at least establish the factual predicate for that. This department has recently reaffirmed that in decisions of LG 70 Doe and Falso. That did not happen here. There's nothing in the notice of claim, nothing in the complaint setting forth any of the three special duty scenarios. And because of that, because this is such an essential element of plaintiff's complaint or claim against the Tonawanda defendants, the complaint must be dismissed because she failed to state a cause of action. If this court were to find maybe she met that and put some facts in there, get past that section, If there is a special duty in this case, we submit it's the voluntary assumed duty. There's no statutory violations alleged. There's nothing saying the town affirmatively placed the decedent in harm's way. The allegations would be the town assumed some type of duty beyond what's owed to the public generally. Where this fails is in the justifiable reliance element, the fourth element of special duty.
Because you signed the waiver.
Because he signed the waiver is one reason, Your Honor, and because the very next day after the town leaves, after they know the town is not taking any further action, he's seeking out additional medical opinions from Roswell. He asks, calls, and as was alluded to, Roswell calls him back. So he's not relying on anything the town's doing. He's going, not to his detriment, he's going out and seeking additional advice.
On this record, could we find an issue of fact as to whether his condition changed a little bit? That his breathing got a little bit worse. He says, gee, I better call Roswell again because my breathing's now gotten a little bit worse.
And there could be an issue, but I don't think that would impact the town as far as his reliance, because I think it reinforces that fact. Listen, I'm getting worse. I got to do something. I'm not just going to sit on my heels. The town said I'm okay. Inaction doesn't satisfy that anyway, but his decision and his wife's decision to say, I need to do something, that takes it away from justifiable reliance. He didn't say, well, the town said I'm fine. I'm just going to go forward and 48 hours later is when he calls 911 again. Something
He wouldn't
happened.
go with the town, right? Wasn't that what happened?
I'm sorry,
He
sir.
wouldn't go with the town when.
Correct. He signed the waiver. The waiver said at the end of
He signed away, he wouldn't go.
he wouldn't go. He had no desire to go. The treatment options were explained to him, and then he remained there. And then afterwards, he didn't call the town again. He called somebody else.
I was gonna say, so
Yeah.
then the next day is when he makes 2 to 3 phone calls to Roswell, correct?
And this whole point that, he wouldn't go, is there any issue of fact at all that he was talked into it by the medical staff?
I don't think so, Your Honor, because what we have in the record is the testimony from the town paramedics saying what they explained to him. And the best evidence is the fact that we have his signature on the waiver. This is not, his wife wasn't present in the room when the conversation was had.
Does that waiver apply to the town? It's a Kenmore Volunteer Fire Department waiver, and it waives Kenmore Volunteer Fire Department. It doesn't waive the town of Tonawanda at all.
And when I reply, we cite I think it's the Fornabayau case, and it talked about how a waiver for one defendant, when you're talking about medical treatment, was good for all. It's still a waiver. He's still saying, I don't want to seek additional treatment. I think that applies here. It shows.
What about the contention, I think, that is being made that there were certain protocols that are followed by the town and they didn't follow those. They should have called the doctors themselves, related to them. It's a doctor's situation, doctor's opinion, and that they should be basing it upon, not upon their own saying, hey, you're probably going to get sent back home, you'll be discharged.
When you talk about the protocols, then I think we're bleeding over then to governmental immunity. To get there, we have to find a special duty first. And I don't think there's a special duty. But if there is an issue of fact on that, governmental immunity jumps in. And when there's discretion and how to make decisions, the governmental defendant is entitled to immunity on that. Now, if there's policies and procedures at play and they didn't follow those, the government defendants can still be entitled to dismissal, to that immunity, as long as they're exercising some discretion. These policies and procedures weren't exclusively ministerial. Again, we see that in a recent case from the First Department. I believe it's called Morales, where it talks about how there was a plan of action in place that these firefighters who were responding to an emergency had to follow. And the First Department went on to say, well, they had these policies and procedures, but a uniform standard of care alone isn't enough. We see when these firefighters are interacting with the person in that case, they're still exercising their discretion. They're coming up with a plan of care. They're assessing his vitals. They're looking at all these things. So even if the discretion is wrong, they're still exercising their discretion. So I think that way, if we're going to get there, even if they were wrong in this case and they didn't follow all their policies, they're still exercising discretion, which makes the immunity come into play. And then finally, the waiver, we believe, speaks for itself. The waiver applies for anyone that was present that day. He signed off and did not want to go. And unless there's any additional questions, we'll rest in our arguments and our briefs.
Thank you, Mr. Goodwin.
Also, could we go right through the governmental immunities and the last part, the second last part, I suppose, but the one about the Morales case, I have Morales in front of me and I'm looking at it. I'm hard pressed to find a distinction here.
Yeah, so I have the Morales case in front of me too, Your Honor. And at first I was like, well, what is the difference here? But then on a more particular read, there is a big difference in Morales. And that's because they say the court is, well, there's a couple different. One is it's a firefighter with basic EMT service. Here we have paramedics who are able to intubate, they're able to give medicine, they're able to give IVs. But also, they find it discretionary. And the definition of discretionary versus ministerial is, I think, very important here. Discretionary is the exercise of reasoned judgment, which provide different acceptable results. Okay. And so in some of the cases, it's hospital A or hospital B. They're different acceptable results. Here they have firefighters where the plaintiff is stable, is not showing any problems with breathing, and they decide to bring her down the stairs. And they could have gotten a chair up there, but they decided to bring her down the stairs because she's not showing any issues with breathing at that point and walking. She ends up having a cardiac event and dying. I liken discretionary, when I went into these cases, as very similar to a malpractice case, where the judgment between two acceptable procedures, two acceptable operations, and that is discretionary. You don't give the charge of a judgment where there's one that's not an acceptable procedure and one that is. In these discretionary cases, they both fit in where there is two acceptable ways of course, and they're choosing between those two acceptable ways of course. And here, in this case, there are not two acceptable courses here. We have a gentleman who is post-surgical, who is short of breath, who in his 911 call, if you listen to it, says, I need to go, I want to go to the emergency room, I can't breathe, I'm post-surgical from Roswell. And the two paramedics, which is very important versus two EMTs, two paramedics come to the Gumkowski house and say, it just must be anxiety.
But they did more than that. I mean, they took vitals. There was an assessment made, right?
Well, there was an assessment made, but they took vitals where a hypertensive person had low blood pressure and he's short of breath and he's post-surgical. And so our expert, Mr. Regan, who is a paramedic, says there is no question here. At that point, you have to transfer to a hospital, okay? And if the patient, and we'll go, because it kind of dovetails into the governmental immunity, if the patient refuses, then there are certain steps, ministerial steps that need to be taken. And Town of Tonawanda has their own refusal protocol, which they totally ignored. They instead adopted Kenmore Volunteer Fire Department's refusal, signature here. They have their own protocol, and that protocol is very specific. If they believe that the patient should go to the hospital and the patient refuses, then they are to advise the patient of the risks of staying home. They don't remember if you look at their deposition testimony, they don't remember if they advised of the risks of staying. Then, if the patient still decides to stay at home, they are to call the medical director, which was a Dr. Krozik. They did not call Dr. Krozik, even though they had the number. If Dr. Krozik wasn't available, then the next step is you call an emergency room and the patient can get on the phone with the doctor to discuss the risks of staying home. They didn't do that. It was not a discretionary decision between going to hospital A or hospital B, or a stable patient going down the stairs or getting a chair to bring them down. This was ministerial and not discretionary. There is a choice that is right, choice A, or leaving a patient short of breath post-surgery at home. Going on to, if there's any more questions between government discretion.
I'm just wondering if there's a choice, a good choice and a bad choice, if that's still not a choice, or if it's when does it cross over into the point where it's like, well, no real choice at all?
Well, there's not a ton of, when I dove into this, there's not a ton of case law in this, but it says all of the case laws really talks about protocols, internal protocols, rules to go by. And this is a case where there are protocols from REMAC and protocols from the Town of Tonawanda that they didn't abide by. So So applying those cases and that thought process of discretionary versus ministerial, it is my position and his plaintiff's position that these were ministerial and not discretionary decisions.
So you don't see ministerial as well. We decide we're gonna do A, and then they just don't do A. That's clearly ministerial, but you wouldn't define it so narrowly that there actually can be some choice in there, but you'd still classify some things as ministerial.
Yes, I mean, I think the overriding thought there's one case where I believe you're talking about where I forget the name of the case. I think it's up where they'll allow the park worker. I don't know if you read that case, but the convict to be employed by the park downstate, and he ends up raping and killing a girl, and they decided that inaction. They didn't use the discretion because they didn't even evaluate and go by their own protocol. Here we have protocol and they ignored it. And so when you have protocol, whether it's from REMAC or from the town of Tonawanda, they just didn't follow their own protocol, and it is definitely ministerial. The majority of the discretionary cases are with the police department and investigating a case and so on and so forth.
So basically, you're saying that it was not a discretionary decision on their part. They failed to follow the protocol.
Absolutely.
They should not be left out. Okay.
And into going in, which I think dovetails into the Fabio decision that worthy counsel just brought up, where it says that a declination for a transport for one is assumed by all. That's not what that case stands for. If you look at Fabio, which is a First Department case, it's easily distinguishable from this case because there was no question of fact in the Fabio case that the plaintiff declined treatment. Here in the record that we have only the decedent and the EMS workers that were around when supposedly Mr. Gumkowski signed this. We don't have Mrs. Gumkowski that was there. All we have is proof on the record that Mrs. Gumkowski said that we're not saying you should go to the hospital. This is most likely anxiety. If you go to the hospital, they're just going to bring you home. You don't need to go to the hospital. That's the proof we have on the record. Here for Fabio, and also to bring up the other proof we have on the record is the paramedics not remembering exactly what they said. Their testimony is all over the place. He needed to go. Well, he didn't need to go. If you look at the testimony in our expert's affidavit, Mr. Regan's affidavit, he pulls out the discrepancy of what they thought, or if they thought the plaintiff should go to the hospital or if the plaintiff should not go to the hospital, which creates a question of fact. For Fabio, there's no question the plaintiff declined the help from the EMT and the other company. I think it was the landowner that was there. There was no question that he did that. Here we have a question of fact of what was said, what risks were given, and what was agreed to by the plaintiff.
This is based on the testimony of the paramedics as opposed to the waiver, which does appear to be clear.
The waiver is not so clear because the waiver in and of itself doesn't absolve town of Tonawanda. It only absolves Kenmore Fire Department. It doesn't, the town of Tonawanda has its own waiver. We don't know what was said to Mr. Gumkowski because no one was there except for the defendant supposedly. So we don't know what was said. There's no.
Yeah, but there's not a factual dispute though. I mean, there's a lack of memory, but is that the same thing as a factual dispute because they can't verbatim or even, somewhat recall what was said. So there's where is the dispute in the.
I think the dispute is in Mr. Rutenberger, the paramedic's own testimony, where he says at one point, I didn't think he needed to go. At another point, he says, I told them they should go. And then another thing, I didn't think his status rose to the level of needing to go to the hospital. So there is that it's not just his memory, which he doesn't remember exactly what was said. Instead, he creates a question of fact with his own thought process of whether Mr. Gumkowski could go or not could go, whether he should go or whether he shouldn't go, and what they advised him to do. His own testimony goes back and forth between the issue. So if he's, as the paramedic is going back and forth between the issue, how can they expect Mr. Gumkowski, who has no medical training whatsoever, is post-surgical, short of breath, he has to go to the hospital, and they say you don't need to go? That's their testimony.
Okay, Ms. Thompson, I think we have your.
Okay,
I
sorry about that.
think I've let you go beyond your, I think I let you go beyond your 15 minutes, so,
No.
I don't think it's lined up.
Yes, absolutely. Really quickly, the justifiable reliance, there is absolutely, that's really the only thing that's in dispute with the four Cuffey elements. There's a question of fact. Mrs. Gumkowski says in her testimony, I trusted them, I relied on them. LG Doe, totally different case. Really quickly, they don't, if you look at the appellate documents, they don't even argue the Cuffey elements. It's a completely different case than the one here. We have argued the Cuffey elements. And last but not least, the history of this case is very important in that after 3 answers, they never put a government immunity defense in this case. They moved over my objection to include government immunity. The Supreme Court allowed that. Now we're moving as to be precautious to amend our complaint so we can go forward. They of course have objected to that. So to allow them to amend their complaint 3 years, and there is a discrepancy in Mr. Godwin's brief. He says that the first time it's brought up is in 2017. That is not the case. It is in record 126 or NICEF document 126. It's 2019 when they actually amend their answer to include government immunity. So
I think that's on your brief, right?
that is in my brief. Thank you so much.
821, Gregory Zuzak is Shirley Sarna. Sorry. Leonard, good afternoon. When you're ready. Right.
Good afternoon, Matt Lenhart on behalf of the defendant estate of Elaine Sarno. May it please the court, the trial court in this case denied the defendant's motion for summary judgment without issuing a written decision. In as much as the motion was essentially unopposed, we can only assume that the trial court's reasoning was that the defendant had not met his initial burden of proof in moving for summary judgment. So that's where I wanted to start. So the defendant met her initial burden of proof in moving for summary judgment on the serious injury threshold by offering the plaintiff's medical records, which are completely contained within the record on appeal in this matter and consist of 10 or 11 pages of documents, the testimony of the plaintiff, and the sworn testimony of the plaintiff's chiropractor. That proof established that the plaintiff is a ophthalmologist who has for many years worked with his hands and small instruments and operating through microscopes. And from 2012 to the time of this accident, a period of 5 years before the accident, he suffered from neck pain, upper back pain, stiffness, and soreness, for which he sought care at a chiropractor. The same complaints that he has alleged as a result of this 2017 motor vehicle accident.
Did the court only see the same parts of the testimony that we did?
Yes, Your Honor. Whatever was before the trial court is in the record.
So there's only 10, 15 pages piece here and there. That's all that.
Of the plaintiff's testimony or Dr. O'Connor's.
So
whatever was in front of the trial court is what is in the
we have in the
record.
record is all the trial court had too.
Yes, Your Honor.
Is that a concern that the court couldn't really get a sense of what was even testified to because it was just sort of cherry picked?
I don't think so, Your Honor. Certainly, we put in our papers. Plaintiff had counsel at the time we put in papers. As soon as we filed the motion for summary judgment, plaintiff's counsel withdrew. Plaintiff had an opportunity to retain new counsel. I think he was given a 2-month adjournment.
You're talking about the plaintiff's obligation to supplement by putting in.
No, I'm talking about in front of the trial court, Your Honor. The plaintiff could
I
have.
apologize. I'm talking about when the defendant put in the exhibits and said attached is the plaintiff's testimony. There's only like 10 pages of the plaintiff's testimony. And so it's hard to gather what the plaintiff's testimony was. And like the example I'll give you just to get into this, the 90 out of 180-day category. Is there anything in those 10 pages that talked about what the baseline was? What were the usual and customary daily activities of the plaintiff? Did the plaintiff play golf 4 days a week and couldn't play golf? We don't know because we only have, page 25, then 26, then 31, et cetera. You know what I mean?
Well, sure, Your Honor. And I guess the reason why I was heading towards the fact that the plaintiff had counsel is because, it concerns me when someone says I would have cherry picked evidence and left out important evidence. The plaintiff certainly had an opportunity to put in any other portion of his deposition transcript if he thought I had in fact misrepresented the contents of his testimony. I would suggest to you that our brief indicates near the end, I'm sorry, I don't have the page numbers at hand, but to address your point about golfing, I don't think he was a golfer, but he does testify that he was a scuba diver, and that he was able to scuba dive. In fact, he said there was no activities that he did before the accident that he was no longer able to do. To address your issue as well in terms of what kind of work he did, again, I don't have perfect recall of what the testimony was, but we attached his tax returns. And the tax returns show that he made roughly $1 million a year. Each of the 2 years before this accident, he made something under $1.1 million a year of this accident, even though the accident happened just about 2/3 of the way through the year. And then the 2 years following the accident, he again made more than he had made in the 2 years before the accident. So to the extent the court is searching for some explanation for his level of activity at work or outside of work, I would suggest again that we have offered you the evidence in the record in the context of his deposition testimony, his tax returns to establish those things. More importantly, Your Honor, so if we're talking about serious injury, in this case, I think it would be wise to just address maybe both claims at the same time, meaning serious injury, actually a new injury, and whether the plaintiff may claim that he suffered an aggravation of a pre-existing condition. Because there is no dispute in this matter that the plaintiff saw the same chiropractor from 2012 to 2017 as he saw a handful of times from 2017 and the year following the accident. And we have the sworn, frankly, because this chiropractor was a friend of the plaintiff and did not create a medical chart. It did not bill anyone for the treatment that he provided. We did a somewhat extraordinary thing and took the deposition of that chiropractor during discovery. And the chiropractor in his testimony is in the record on appeal. His testimony was that, did you make any new diagnosis following this 2017 motor vehicle accident? No. What was your diagnosis? Strains and sprains. Why was that? Because he didn't.
We have all that.
Okay, so my point on that, Your Honor, is that there's no objective evidence of a new injury, no objective evidence of an aggravation of a pre-existing condition. The other part of serious injury that we haven't yet addressed, but sort of did in response to the golfing questions from Justice Nowak, is whether he was disabled to a significant extent. And I believe we've established that through his financial records, through his deposition testimony, when he said there was nothing that he was unable to do following this accident.
But I guess if he could have done more work, he says he wasn't doing afternoon work, as far as that, seeing patients or doing surgeries. And so if he could have done those, wouldn't he have made more than $1 million or more than that?
I don't know, Your Honor, and that's the problem with the plaintiff not opposing the motion, right? So what we do know is he testified in that deposition testimony is attached to the record that he testified he did not cancel a single surgical procedure because of this. He had a full.
Didn't he allude that I don't do afternoons? Basically.
Yes, Your Honor, but I think the dollars and cents sort of bear that out. And again, the question is, did we meet our burden of proof? I don't know what else you could offer at this point, Your Honor, other than the sworn testimony of the doctor, the sworn testimony of the plaintiff, and his tax returns on all of these issues.
And everything that's in your brief.
Yes, Your Honor. Last point I would just like to make, which is that at this point, the plaintiff is obviously a pro se plaintiff. And He has been since the time the note of issue was filed in this case. I think there's a natural desire to make sure someone gets every fair opportunity that they can to be heard, and I certainly do not want to deprive Dr. Zazulak of that. However, that does not excuse his failure to put in any papers opposing the motion. It does not excuse his citation to records that not only were not included in part of the record of appeal, were never provided in discovery. So I'd ask you to hold the plaintiff to the same standard you would any other litigant before you in this court.
Very good. Thank you, sir. Dr. Zazulak, sorry.
Zazulak, yes, thank you.
Zazulak, apologize.
Can you hear me okay?
Yes, we can.
Okay, thank you. Good afternoon, your honors. Thanks for.
Did you understand the last comment made by Mr. Menard as far as documents that were not presented below really can't be considered by the court?
All the documents that I presented, I had given to my attorney to present to the court.
That
So-
doesn't,
But it's still not part of the record. You know, all we can deal with is what's in the record. So if you can make some arguments in relationship to what's in the record.
I believe all the documents that I'm talking about are in the record. There aren't a lot of documents.
Right. Why don't you make a couple comments then? I mean,
Okay,
how are you affected by this as far as the injuries that you've sustained? Do you have any? I think there was an X-ray, right? Was that the most objective piece of evidence we have? There was an X-ray, but there was not an MRI or anything like that. Is that correct?
I had X-rays and I had examinations with both the chiropractor and with the neurosurgeon, Dr. Boev.
Right.
Okay, this accident occurred back in August of 2017. Okay.
Right.
That's more than 8 years ago.
Right.
Okay.
And you're still experiencing some of these pains or ailments. That's continued. Is that your
Yes,
your contention?
I still have restricted range of motion and I still have spasms and pain. Okay. And I went through all the treatment protocols that were recommended as far as the physical therapy, the anti-inflammatory medications, the chiropractic treatments, and it was the determination of both Dr. Boev and the chiropractor that my recovery had kind of plateaued and the situation is what it is. Okay. And Mr. Lenhard is suggesting, and he specifically wrote in his briefs that he says, quote, my alleged injury, which was temporary, mild, minor, and slight. Okay. And honestly, I find that offensive. I mean, for him to belittle that, it's been a significant thing.
Right. And it's your contention that you're opposing that. So you're feeling that you're still experiencing these pains and ailments that have affected you from this accident, so many years ago.
That's correct.
All right.
Okay. And both
Is
of
it your
the
contention?
doctors
Is it also your contention that there's certain activities that you cannot can no longer take part in to the same degree that you were able to before the accident?
There isn't any specific activity that I can't do, but the duration that I can do the activities is significantly reduced. So when I was answering his questions before, when I did the deposition, basically what I was saying was that I could still do the surgical procedures that I do. I could still do the outdoor extracurricular things that I do, but I can't do them as long as I did, and they're not as enjoyable as I did. And I showed that the amount of surgical procedures and the amount of the day that I could spend in the operating room working is reduced significantly. Okay. And I have
I think we're aware of that because you indicated that you're not doing any office, visits in the afternoon, or you're not doing any surgeries in the afternoon. So it's somewhat curtailed or limited you in that respect.
That's
correct?
correct.
Okay, all right. I think we all understand that. Did you want to specify or stress anything else to the court as far as that's concerned? Because we're very familiar with the fact that you feel that I think you're saying that these injuries, or this accident exacerbated your injuries. Is that fair to say?
Yes, it is, Your Honor. I would like to point out that I asked both of the doctors to provide a summary statement about my situation and my condition. And Dr. O'Connor said that my neck was, quote, much stiffer after the accident.
We
And,
have all that.
Right. We've seen
Okay.
those letters already. So
and Dr. Boev said that my range of motion is 40% of normal, which means it's 60% reduced. And he said, quote, from a functional standpoint, he is certainly affected from the motor vehicle accident on a long-term basis. And he has essentially plateaued in the recovery.
okay, very good. Anything else, sir?
Yes, there are a few more things, Your Honor. When Mr. Lenhard presented his documents, he conveniently overlooked and ignored not just those written summary statements, but he completely ignored the letter that I received from the chief administrator at the Brighton Surgery Center, and that's where I do all my surgeries.
Right.
Okay, and in that letter, the chief administrator said that the surgery center has spent money to buy multiple pieces of adaptive equipment to help me overcome the issues that I'm having with my neck. Okay, and they spent money for that, and the timing of that corresponds with when I had the accident. And even after getting those,
right. And that sort of supports the fact that, you're limited in what you can do. I think that's your contention, correct?
correct,
Okay.
correct.
Do you have anything else, sir?
Yes. As far as the financial things, okay, basically, when Mr. Lenhard talks about my tax returns, it's not really portraying the reality of the situation. Okay, it's true that the receipts in the practice may have gone a little bit higher in 2017 than in 2016. Okay, but that doesn't prove that this neck injury had no economic impact on the practice. It's incorrect. Okay, the reality is that there's a significant delay between when the medical and surgical services are rendered and when the practice receives payment for those things. Sometimes it can take over a year. Okay. In addition, around the time of the accident was when several important things changed in the world of eye surgery. Specifically, two things changed. Okay. One is that using premium kind of lens implants at the time of cataract surgery became more widely available. And by doing that, it gives us the opportunity to let patients see a lot better without glasses. And it gives us an opportunity to earn more money per time period. And the second big development that happened around that time is that a technique called a MIGS procedure, which is a glaucoma surgical thing that can be
Right. I think that's not in the record, I don't believe, sir. So I think we can't consider that right now.
It's not in the record.
Right. All right. Is there anything else, sir?
Um,
We've read your brief and we hear your argument, and And we'll take all, everything in, carefully and look at that.
Okay, well, the only other thing that I would say is that, you know, a trial would be the time that we could bring out the truth about facts, because a lot of the things that were presented by the opposition are not accurate. And,
Okay.
and a trial would let us
That would-
find out what is true and what isn't true.
Right, that would help. Okay, very good. Thank you, sir. Have a good day.
Thank you.
Thank you. Last. Matter of Sandra Dorley versus Andre Evans. It could. You are not Martin McCarthy?
Sorry, no, I'm Daniel Strollo as a substituted petitioner.
Okay.
This action, the caption changed.
And the change in what respect?
I am now the petitioner as Special District Attorney of Monroe County.
Give me your name again.
Strollo.
Daniel, right?
Yes,
All right, sir, thank you.
thank you. Imagine being a young woman who wants to engage in civil service, being solicited to join your now boss in a new role as town supervisor, and then almost immediately being subjected to heinous and repeated manipulation and sexual harassment.
She was the chief of staff, right?
Chief of staff to the respondent, yes.
And that generally has a very detailed, significant responsibility.
Intricate responsibilities, close working relationship, and a deep level of trust that exists between those two type of individuals. And here we have that respondent who exercises a position of significant power over her, not just by virtue of the appointment that has been made, but because she's left her previous employment for this newly created position, left her other job opportunities to pursue her career. And then she's told that her legs are pretty.
You don't have to go through it.
Okay.
You put all that down and remember, we're not a jury, okay?
Certainly, isn't a original proceeding. I only say that because I need to emphasize that, and of course, I'll refer to the briefs, but the respondent characterizes this heinous conduct as petty slights and trivial inconveniences. Those are not petty slights or trivial inconveniences, and it's disturbing to have a public servant in a position like that in a proceeding such as this downplay that conduct.
So you're looking for us to refer this to a hearing officer, correct?
I think that it could be decided on the papers. I don't believe that the respondent, by simply issuing, denying this, issuing flat out denials, rather than presenting evidence to contradict the allegations, which can be done in some instances.
So we're very familiar with the allegations that were made with respect to the comments that were made to not only the chief of staff, but others as well. Does that, and according to public officers law, section 36, it must have got to rise to something that's to be removed from office by the Supreme Court for any misconduct, maladministration, malfeasance, or malversation in the office. Are you claiming that these reach that level?
Absolutely, with not just his conduct with respect to the chief of staff, but also his directives to the police chief to remove individuals that opposed his remaining in office at the town board meeting, directly telling the chief of police to.
Where?
Certainly. I think that rises to the statute as well. And I think that the conduct complained of here is arguably more egregious than any identifiable conduct in case law where appellate divisions have upheld removal. This conduct on its face is unacceptable, but to do that as an executive, you subject your town to liability. The town is subjected to liability because of this. And then to double down and then retaliate against the person by stripping her of her job duties. And then once she tries to go to HR and then refuse to take any remedial action as directed by the board, it just goes on and on and on. What else?
Right.
Could
But
we
you're taking
possibly
a
do?
different position here because your brief says the allegations in the verified petition, if established after fact finding, would constitute a pattern of misconduct and abuse of authority. And I think you say should be referred to a,
Jury.
yeah.
So that, I think that Obviously, I took over this case last Thursday. I'm just looking at this holistically. I think on the papers before you, you could make that determination based upon the nature. the
And if not,
respondents-
perhaps it needs to be referred.
Yes, and I think that should be done expeditiously because this does bear the risk of becoming moot.
No, I understand that.
Sure. If there's any further questions, I'll take them. Otherwise, I'll rest on the papers.
Thank you.
Thank you.
Mr. Evans? Or Nicholas Jacobson, I'm sorry.
Yes, Your Honors.
Apologies.
Good afternoon, Your Honors. May it please the court. I'm Nick Jacobson. I'm a member of Bond, Chenick and King, attorneys for the respondent, Andre Evans, town supervisor for the town of Irondequoit. As was just noted, before the court is a petition seeking.
We know exactly what must be before the
Sure.
court.
The standard at play is a very high bar. Courts have observed that removal under section 36 is a drastic remedy reduced for malicious and corrupt acts. During his time as a state court judge before joining the Northern District, Judge Kahn noted that in evaluating whether removal is appropriate, the court must consider the sacred right of the people to choose their elected officials. And he also noted that section 36 is in no way intended to interfere with this vital aspect of democracy.
Does that go hand in hand with your argument then that with respect to the actions by the board were taken relatively soon or before close proximity to the nominating process of the Democratic Party?
Sure, Your Honor. I think absolutely the circumstances indicate that there might be political reasons for this petition being brought, but I don't think that that's critical to our analysis of whether the petition is sufficient on its face to justify removal. And I think there are two reasons that it is clear that the petition is not sufficient and there are no triable issues of fact. The first being that many of the factual allegations are not supported by the evidentiary record attached to the petition, and also the allegations in the petition do not rise to the level justifying removal under section 36. On the first point, for instance, the petitioner's allegation that Supervisor Evans sought to use the police department to silence his constituents is totally unsupported by the affirmation of Chief Peters that accompanies the petition. In one instance, it's alleged that Supervisor Evans sought to silence an individual who was sending strange emails. But if you look at Chief Peters' affirmation, all that he has alleged is that the emails were received. He sought a professional opinion from the chief law enforcement officer of the town as to whether there was a safety risk.
And we're aware of that too.
So again, yeah, I think it's clear that the allegation in the brief or in the petition is not supported by Chief Peters' affirmation. There's no indication that he even followed up with Chief Peters after Chief Peters gave him the determination that there was no safety risk. And Chief Peters himself said he would continue to monitor the situation and take additional action if things escalated from
Right,
it.
and then the other, he removed the signs, I think, or asked the individuals to put the signs down.
Exactly, yeah, and there was a disagreement.
Have all that in front.
Sure, absolutely, Your Honors. Similarly with Ms. Bailey, and I won't belabor the point because I know Your Honors have this in the papers in front of them. I don't believe that her allegations in her affidavit are consistent with the allegation in the petition that Supervisor Evans sought to have her silenced through an intermediary or to retract her statements. Again, there's no allegation that Supervisor Evans asked that individual to speak with Ms. Bailey, much less that he was aware that that conversation was occurring and asked that she retract her statements. With respect to the allegation that he stared at an employee,
Right.
I don't see how that could conceivably justify removal under Public Officers Law, Section 36. So what we're left with are essentially the allegations that are discussed in the Near Pass investigation report. The Near Pass investigation, the investigator concludes three things. She concludes that it is more likely than not that Supervisor Evans made gender or sex-based comments, that those comments arose to be more than a petty slight or a trivial inconvenience, and that he effectively cut an employee out of job responsibilities. I'm in no way condoning sexual harassment to any level. But to the extent that the petition really relies on, if you look at petitioner's brief, they have 9 bullet points identifying
what they are.
comments that are supposedly made, some of which aren't even overtly sexual on their face. The idea that these episodic comments, apparently approximately once for each month of employment that that individual had with the town, to say that that reaches the level justifying removal under public officers law, I think that can't be said. I think it's glaringly absent that petitioner has not cited a single case in their brief.
I think you cited some cases which are similar, or could be arguable, in support of your client's contentions.
I did, Your Honor, and I think the 2 cases cited by petitioner where a petition was actually allowed to advance beyond the summary disposition stage that we're at today are markedly different. For example, Greco v. Jenkins, 11883rd 1248. It was alleged that the mayor withheld funding from the police department and was caught on camera uttering numerous racist remarks and threatening police officers in relation to criminal charges that they had filed against him. Similarly, in West v. Grant, it was alleged that the supervisor was engaged in self-dealing with respect to insurance contracts entered into by the town, and that he was also stealing gasoline from the town. There's no precedent that the petitioner has identified that would indicate that the allegations in the petition could rise to the level where they would justify removal. So for that reason, unless the court has questions, I'd rest on my brief and submit that the petition should be summarily dismissed.
Thank you for your time. I really appreciate your patience. You've been here a long time.
Thank you,
You
Your
guys are
Honor.
probably hungry.